Joining us now on the Newsline is Mark Chenoweth. Mr. Chenoweth is President and General Counsel with the New Civil Liberties Alliance. Mr. Chenoweth, good morning. Thanks for taking time to talk to folks across the state of Iowa.
Good to be with you, Jeff.
Tell us, first of all, about NCLA, the New Civil Liberties Alliance. Who are you and what do you do?
Well, we are about 6 years old, and we were set up with the sole mission of trying to keep the administrative state in check. Our founder, Philip Hamburger, is a law professor at Columbia University Law School in New York, and he had written a book called Is Administrative Law Unlawful? And the short answer is yes, it is. And so what we're trying to do is set up constitutional guardrails and force those administrative agencies to follow the Constitution and stop violating people's civil liberties.
So 35 years ago when I was in law school, there was a course called Administrative Law, and the way it is being handled and applied today is far different than what some of us learned in law school. Let's start without getting into some of the specifics, which I do want to, but where did we get to this point? Senator Grassley and I have talked about this on the program before, where the administrative state, if you will, has just gotten out of control. He blames Congress for not keeping a firmer hand on the till, but tell us how this got out of hand.
Well, I think Senator Grassley is absolutely right that Congress not keeping a hand on the till is part of the problem, and being all too willing to pass off controversial decisions to folks in the executive branch rather than Congress serving its role under the Constitution as the policymaker in chief and making those tough votes on a variety of controversial issues. But it's more than that. It's also that these administrative agencies have taken shortcuts, the path of least resistance, and the courts have not shown the backbone to stop the agencies from doing that. In fact, in many ways, they have facilitated the ability for administrative agencies to do that with something called deference doctrines. These are judge-created doctrines that defer to the administrative agencies. The most famous of these is Chevron deference, where courts will defer to agencies' interpretations of federal statutes if there's an ambiguity in the meaning of the statute.
And I think some of this derived from the concept of, and it really got out of hand with the Internal Revenue Service, but it was, in essence, Congress, well, the Constitution allowed ultimately an income tax. Congress sets up the IRS, Congress sets the rates, and then it's like, okay, you folks figure out where they mail their payments. I mean, that's the short of it, that the agency handles more of the detail-oriented stuff. Congress would take care of big picture. But the reality is these agencies have just run amok in interpretation that may be so far away from the statutory intention that it's unrecognizable. Or am I overstating?
No, I think that's right. The early Supreme Court cases on this said that it was okay for administrative agencies to fill up the details. And then the question over time becomes, okay, what's a detail? It's like the old joke about the husband and wife who get along because the husband makes all the big decisions, the wife makes all the little decisions, but the wife gets to decide which decisions are the little decisions and which ones are the big decisions.
Yeah.
And so that's sort of what we have here is the administrative state is making big decisions, but it's pretending that it's not, and the courts are letting it get away with that sort of approach.
Mark Chenoweth is the President and General Counsel of the New Civil Liberties Alliance, and he joins us live on News Talk 1540 KXEL. You were given the opportunity to speak at a public hearing about some of these unlawful, unconstitutional student loan debt bailout efforts by the administration. Give us a sense of how this popped up on the radar and explain why you're taking the position you are with regard to this issue.
Sure. So maybe I can break that up into two. So the way this came about is the Supreme Court handed down its decision on June 30th in the Biden v. Nebraska case, and this was the case where several state attorneys general, including Iowa, had sued the Department of Education and the Biden administration over its attempt to forgive about half a $500 billion. It's hard to believe that the number is that big of student loan debt under the HEROES Act, which was a law passed by Congress in the wake of 9/11, where they were essentially trying to say, look, if some soldiers are getting called to active duty, reservists and what have you are getting called to active duty, they're going to get paid less in some cases in those military roles than they were getting paid in the private sector. And so we want the Secretary of Education in those cases to be able to provide some student loan relief to those individuals so that they don't, as a result of getting called up to active service in the military, don't start defaulting on their student loan debt. That's what that law was about. And the administration decided to treat it as something giving blanket authority to forgive student loans, which it never was, and the Supreme Court saw through that charade. Well, in the wake of losing that battle at the Supreme Court, rather than sort of tuck its tail between its legs or take its lumps, the Biden administration, the Cardona Department of Education, reached around or looked around for another statute that it could latch onto, and it's decided to latch onto the Higher Education Act of 1965. Well, there's a few problems with that, including the fact that the Department of Education didn't even exist in 1965. So the idea that that statute somehow gave the Secretary of Education the power to blanket forgive student loans is just as fanciful as the idea that the HEROES Act gave the Secretary of Education that power. If you're going to forgive $500 billion in student loans, Congress needs to be the one to do that. Congress has to speak clearly that it wants to do that, and that just hasn't happened yet.
If I understand the analysis correctly, there are folks who said, all right, you've got two possible pieces of legislation you can rely on. They rejected the one they're using right now because it had the worst chance of being successful. So they went with the one that had the stronger case in their mind. That got swatted down. So this is not just Plan B. It's a weak Plan B, especially in the light of the Supreme Court ruling saying Congress is the one with the authority. Is this just a stall tactic to get through the next election because they know this doesn't have a prayer of being constitutional?
I do think that's part of it. It's a stall tactic. I think they think the longer that they can push this out, the longer that folks aren't making these payments, they know they're making the problem worse. And if they can make the problem bad enough, because you have all these folks who were making, you have to understand that a lot of the folks who got the relief during the pandemic where they were told you don't have to make your payments, a lot of those folks had been making payments consistently up until the point where the relief came in. But once the relief came in, even folks who'd been making consistent payments, a lot of them thought, well, geez, I might as well stop making my payments and spend that money on something else for a while. Well, then once you restart the payments for all those folks, some of those folks, maybe they've taken on a car payment, or maybe they've done something else with that money. They've gotten used to a certain lifestyle. Maybe they've picked an apartment that's more expensive or a little bit bigger than what they would have if they had to make a student loan payment. It's difficult for those folks to get back on the student loan payment train, and the administration recognizes that, and they're trying to leverage that into a reason to forgive student loan debt. If Congress wants to go along with that, that's Congress's prerogative, but it's certainly not the case that the Congress of 1965 went along with that idea and was in favor of that sort of policy action, or gave the executive branch the ability to make that decision. And in fact, the analysis from the Biden v. Nebraska case at the Supreme Court is very clear about this. It talks about the major questions doctrine, which says that if there is this sort of major policy-making decision that's going to involve major impacts on the economy, as forgiving $500 billion in student loan debt would do, then Congress has to be the one to make the decision. Congress has to speak clearly. There has to be clear statutory authority. And the statutory authority, to the extent there is any in the Higher Education Act, it's just as vague, just as I think merely colorable was one of the phrases that was used to describe the language in the HEROES Act. That, yeah, you might be able to make an argument, but there's certainly not clear authority. Well, the Higher Education Act's the same way. It gives the Secretary the power to compromise loans. Well, what does that mean? That means you can try to maximize the amount of money that you're getting back from any particular student loan debtor. So if you've taken out $10,000 in debt and the Secretary of Education is looking at your case on an individualized basis and says, well, we know based on all these factors that this particular person isn't ever going to be able to pay us back the $10,000, but maybe they can pay us back $5 or $7 or $8. And then they can compromise that loan and agree with that individual that they will release them from the rest of their debt if they pay back that other amount. Well, that's compromising a loan. That's trying to maximize the return to the taxpayer from that loan. Well, that's not what you're doing if you say, hey, we want to compromise these loans. We're just going to forgive $10,000 and then you won't owe it anymore. Well, that's just misunderstanding what the statutory power is that's being given to the secretary there, and quite deliberately, I would say, misunderstanding that power, and the courts are going to be wise to that.
I was going to say misunderstanding is a very nice, legal, charitable phrase, but and I appreciate the politeness. No, it's a matter that, again, if it's a case-by-case write-down or compromise or settlement, but not when you're talking about tens and hundreds of thousands in one fell swoop with the stroke of a pen.
That's right. That's right.
What are some of the other things? By the way, we're speaking with Mark Chenoweth. Mr. Chenoweth is president and general counsel of the New Civil Liberties Alliance. They are online at nclalegal.org, nclalegal.org. What are some of the other cases that you folks are paying close attention to lately?
Well, I'm happy to circle back to that, but I thought you had asked about the hearing that took place, and I thought I might talk about that briefly.
Sure.
The reason that they're we talked about the Higher Education Act being sort of Plan B or a weak Plan B.
Yeah.
One of the reasons why they probably didn't go that route in the first place is because it's a very time-consuming process as well, and it involves something called negotiated rulemaking. And without getting into the weeds of what that involves, I'll just say that it takes 15, 18, 21 months, something like that, in order to go through negotiated rulemaking. One of the early steps on that is calling this public hearing, which they did, and that's what I testified in front of on Tuesday. It was just a Zoom hearing. My understanding is that in the 4 hours of hearings, there were only 2 people who testified against loan forgiveness, me and one other person, and these were 4-minute testimony slots, by the way. So that just shows you the sort of the overwhelming tenor of the testimony there. But one of the things that I wanted to tell them, in addition to the things that you and I have already talked about here about the major questions doctrine and so forth, is that the Constitution forbids what's called suspending or dispensing power. And that's a sort of a fancy legal term, but essentially what it means is the executive branch can't say the law applies to some people and not to other people. That was a royal prerogative that some of the kings of England were allowed up until about the time of James II, when he was removed from power for abusing that power. And that was never allowed in American history. The American colonists never tolerated such power in executives. The U.S. Constitution does not tolerate that sort of suspending or dispensing power. If Congress wants to come along and exempt certain people from the law, they can pass a new law to do that. But it's never been the case that the executive can say, we're going to apply the law to some folks and not others. Now, this is different than, say, prosecutorial discretion, where a prosecutor can choose to prosecute or not prosecute someone for different reasons. This is just saying, in this context, it would be saying, even though the law says you have to repay your debt, we're going to decide that those people in this category don't have to repay their debt. And it's just not something that the executive branch has the power to do. And in fact, the Supreme Court has spoken on this quite recently, at least seems recently to me, 1998, in the Clinton v. City of New York line item veto case. One of the reasons why the court gave for saying that the line item veto was unconstitutional was that it would essentially allow the executive branch to have this kind of power of deciding that the law would apply to some folks and not others. And again, that royal prerogative that has not existed in American history, but that royal prerogative is what President Biden is trying to resuscitate and pretend like he has. And remember, the other thing the Supreme Court pointed out, Chief Justice Roberts, in his opinion in Biden v. Nebraska, pointed out that Speaker Pelosi had said that the president can't do this on his own, that it requires a vote of the Congress in order to do this. Nancy Pelosi said that when she was the Speaker of the House. She was right, and the Biden administration is still trying to find ways around that that impediment.
Mr. Chenoweth, important work that you folks do. Lots of great information in this conversation. Thanks for the time today. I trust we'll talk again.
Look forward to it. Thanks, Jeff.
Thank you. Have a good weekend. Mark Chenoweth, he is the president and general counsel with the New Civil Liberties Alliance, and they are online at NCLA, for New Civil Liberties Alliance, nclalegal.org.